disclaimers. And we gave a couple of these their own slides because these are really important and it'll help explain a little bit of what we can and cannot answer today. Today's meeting is intended to be only informational. ADWR is not and cannot take sides in this election. And the information you'll hear today is not intended to be comprehensive, and it is not intended to be legal advice. We would really encourage you all to consult with an attorney if you have specific questions about your specific circumstances. We do have time set aside at the end of today's meeting for questions and answers. This is intended to be a time to ask questions and get clarifications. This is not intended to be used as a platform to advocate for one side or another in this election. So if you do choose to speak during this time, please do limit yourself to questions about the contents of today's meeting.
Natalie pretty well covered this, but as she mentioned, we are required by law and we are completely neutral with respect to the election. And so I know that there are folks who have strong opinions and who might like to come up and give their opinions one way or the other, but we would respectfully request that you refrain from doing that, limit it to questions only, because we don't want there to even be an appearance that this is a one-sided event or that we are here to advocate for one side or the other. I did see that there are some papers that are circulating that might be advocating for one position or the other. Those did not come from ADWR. I just want to make that clear. We didn't specifically anticipate that or ask that people not do that ahead of time, but we just want to make sure that people understand we are not circulating those pamphlets advocating for one side or the other.
So the next couple slides here will add to that a little bit. There are going to be questions today that we are not going to be able to answer. Like we've said, ADWR is neutral, and this meeting will focus exclusively on the process around the theoretical event in which an AMA is established in this election. And all of the details, some of the details at least, of what would need to be done to establish that subsequent AMA. We will not be discussing hydrology in today's meeting, but in the slides in today's presentation, which will be posted on our website, we'll provide some links to information that is available on our website. Oops, yeah. And we do recognize that there's a lot of uncertainty here. Tonight's presentation might answer some of your questions, but in some cases there is just uncertainty in how specific details will play out. If either of these ballot measures passes, this would be the first time that a subsequent AMA has been established. And because it's the first time for that, we'll be interpreting and applying many of these statutes for the first time. By election, yes. We won't speculate where there is uncertainty because we want to make sure that we are providing you all correct information. So we will only be explaining those things that we do know in today's meeting. So please carefully note when we are talking about how things are done in existing AMAs as opposed to the statutory requirements for subsequent AMAs. And I'll point that out a little bit in later slides. We do have a significant amount of information online. Like I said, this presentation will be posted online, so don't feel like you need to scribble down these web addresses. These links will all be available. But we do have FAQ pages for each of the basins because the details of Douglas as compared to Willcox are a little bit different. We also have information on hydrology posted on our website. So information about land subsidence and the locations of subsidence features. We have information about groundwater level changes. So how water levels in a given area have changed over time. And we also have a model report for the Willcox Basin specifically. A lot of that can be really technical. There's some information available also under the Water Atlas that's a little more plainly written and not as technical in nature. So those resources can all be really helpful. Information about our existing AMAs. So again, the details there might be a little bit different than a subsequent AMA, but there's also a lot of information on our website available about existing AMAs and how the management plans and the details of the regulations play out in those existing AMAs. The next slide we have here is something we will put back up on the screen at the end of the presentation once we get to the Q&A section. We do have speaker cards available at the sign-in table, and we'll also have a virtual speaker card for those of you on the webinar, so you'll be able to ask questions as well. Like I said earlier, we do ask that you limit any questions to the topic at hand, and we do ask that you all be respectful. We know that this is a difficult topic. It's a complicated topic. So we do ask that everyone be respectful of each other so that we can make the most of this time that we do have. Today's meeting will end at 8 o'clock. So that 3 to 4 hour thing, sorry about that. We will end today's meeting at 8 o'clock. So we do ask that folks limit themselves to maybe 1 or 2 questions just so that we can get through as many people as possible. We will alternate between in-person and online comments as we work through the speaker cards that we've received. Again, I'll have this slide back up on the screen once we get to that point in the presentation. So with that, we will go ahead and move into the informational part of this presentation. We're going to throw a lot of information at you. I understand that a lot of this is dense and there's a lot of complexity here. So we're going to do our best to lay a little bit of a groundwork, a base level of knowledge for everyone before we get to the Q&A part of the presentation. So the statutory framework for most of what we're going to cover tonight comes from the 1980 Groundwater Management Act. And you'll hear us refer to the Groundwater Management Act or the Groundwater Code a lot. So this act was really important for us. It created ADWR and it created regulations for groundwater use in certain parts of the state, which is important for this because it authorizes the establishment of additional active management areas or additional regulated areas by election, which is what's happening now. ADWR is responsible for administering the requirements established in this act, including permitting and reporting requirements, implementing conservation requirements for water users in the AMAs, and a lot of the other details that are established there. The structure of the Groundwater Management Act is additive. So there are some requirements that apply statewide. So a registration of all wells, adequate water supply, community water systems, these things apply in both Willcox and Douglas now today, because these are statewide requirements. For an irrigation non-expansion area or an INA, there are additional requirements that apply on top of those statewide requirements. The expansion of irrigated acres is prohibited, and there is measuring and reporting required. In an active management area, this is our highest level of regulation for groundwater. So there are additional requirements that apply in addition to those in an IMA, in addition to those statewide requirements, including management goals, management plans, conservation programs, and grandfathered rights. The initial AMAs were all established by statute, and the footprint of those AMAs has not changed since the establishment of the 1980 Groundwater Management Act. The 1980 Groundwater Management Act actually established 4 AMAs And the Santa Cruz AMA was eventually split out and added, but it was, the Santa Cruz AMA was originally in the footprint of the Tucson AMA. So like I said, the footprint of those AMAs has not changed. All right, so what is an AMA? What is it that we're referring to when we talk about an AMA? A few of the major characteristics that we're going to talk through tonight are management goals, management plans. In the management plans, there are conservation programs and annual reporting requirements. There are wells requirements under an AMA. There are groundwater rights and withdrawal authorities that are established under an AMA. And an AMA has assured water supply. I'm not going to go into detail on these things yet. What we're going to do is we're going to work through each of these items, talking through how they apply in an existing AMA and how they would apply in a subsequent AMA. But these are going to be important terms that come up over and over again. So we wanted to make sure we had a little bit of an introduction to them. So the designation of a new AMA by local initiation and election is why we are here today. We want to talk about what is coming with the upcoming election, what would happen if one or both of those measures passes, what the major steps and requirements are in establishing a new AMA, and we'll also cover each of those items from that previous slide and many of the major topics that we have on our FAQ page. So where we are now, right now we are in the Willcox groundwater basin. The Willcox groundwater basin covers areas in 2 counties, in Cochise and Grand counties. And the Willcox groundwater basin is currently only governed under those statewide requirements that I mentioned earlier. There is what we call mandatory adequacy in Cochise County, in the Cochise County portion of the Willcox groundwater basin. We'll cover a little bit of what that means later in the presentation. The Douglas groundwater basin is located fully in Cochise County. So again, Cochise County has that mandatory adequacy requirement that we'll talk about later. The Douglas basin is a little bit unique because it does have an INA in it, but the INA, or irrigation non-expansion area in Douglas, does not cover the entire basin. It's kind of a gridded shape on the inside of the basin. So there are areas in the Douglas groundwater basin that are currently an INA, and there are areas in the Douglas basin that are currently only subject to those statewide requirements. So that adds a little bit of complexity when we talk about the Douglas groundwater basin.
So many of you are aware, Cochise County has received 2 separate petitions to designate, or to hold elections essentially, to designate new AMAs. One for the Willcox groundwater basin and one for the Douglas groundwater basin. The county has determined that the petitions it received were legally sufficient and have informed ADWR that they do intend to call for an election for both of those basins on August 30th. Oh, did we lose our slide? Yeah. When the county, and assuming that the county makes the call on August 30th, there will be in effect a temporary freeze on the irrigation of new acres within the basins. And I'll talk about specifically what that means. So essentially, only acres of land that were legally irrigated at any time prior to the 5 years preceding the call for an election may be irrigated during this freeze period. And the freeze remains in effect until the results of the election are certified by the Board of Supervisors of the counties that are involved. So for the Willcox Basin, that would be both Graham County and Cochise County. For the Douglas Basin, that would be just Cochise County. So when the results are certified, one of two things could happen. Either the election results in the designation of a new AMA, in which case the prohibition on the irrigation of new acres remains in effect with some slight variation, and we'll talk a little bit about that. Or if the result is that no AMA is designated, that prohibition is lifted. At the time that the counties, Graham County and Cochise County, make calls for an election on whether or not to designate new AMAs, the department will send out notices. The department's not required to do that by law, but we will be sending out postcards to landowners within the landowners according to the county assessor's records, so that folks know that that temporary prohibition is in place. We will also publish notice in the newspaper of that. Before we move away from this, so I think it's important for folks to know what the definition of irrigate is. So irrigation is defined in the code as applying water to 2 or more acres of land to produce plants or parts of plants for sale or human consumption, or for use as feed for livestock, range livestock, and poultry, or poultry. Okay, and I sort of already touched on this slide. So, this is what would occur if an AMA was designated by election with respect to which acres of land could continue to be irrigated. Only acres of land that were legally irrigated at any time prior to the 5 years preceding the call may be irrigated with any water except as provided below. So with respect to the temporary freeze, that applies to all irrigation. When we're talking about if an AMA is designated, the prohibition on irrigating new acres does not apply to acres of land. Sorry, hold on. I'm reading this. That were irrigated with a decreed or appropriative surface water right established before the date of the call for the election. So that type of irrigation relying on a surface water right, decreed or appropriative surface water right that was established before the date of the call is not subject to this prohibition. And then I'd also note acres of land that are not irrigated during the relevant 5-year time period will be deemed to have been irrigated. So they will be allowed to continue to be irrigated if a substantial capital investment has been made to bring the land into irrigation within a particular window of time. And I have a slide a little bit later on that I'll go talk a little bit more about substantial capital investment. I know that that is an area where folks have a lot of questions, but I'll talk a little bit more about that in a bit.
Okay. So if a new AMA is created, we will have to work through a number of items to establish the requirements for that AMA. The list on the screen here is not comprehensive, but shows some of the major items and is kind of intended as a reference for the statutory language for that item. Establishing a goal, developing and adopting a management plan, the submission and processing of applications for grandfathered rights, which is important to note that there is a requirement that folks apply for those grandfathered rights, and the development of rules for AMA-specific requirements related to assured water supply. Like I said earlier, we are going to be switching back and forth here a little bit. So I want to point out the notation that I have on the slides. You can see on this slide here that we're referring to the initial AMAs. So that means that this is specific to the requirements or the ways things work in those existing AMAs. And again, there are going to be some things that are a little bit different for subsequent AMAs. So I'll clarify that. What we wanted to point out here is that the management goals for all of the existing AMAs were established in statute. That's not something that was developed. So this process is different than that, where the management goal would be proposed and would go through a hearing process. All of those goals were adopted, excuse me, by statute. So we do have, in the existing AMAs, we have 5 AMAs. 4 of those 5 AMAs are essentially safe yield AMAs. And again, safe yield is defined in statute. So safe yield looks at the AMA and looks at groundwater withdrawn in an AMA and the amount of natural and artificial recharge in an AMA to look at the long-term balance of water in that AMA. So safe yield, the kind of baseline definition of it is that we are attempting to achieve a long-term balance between what's going in and what's coming out of that aquifer. For the canal, actually I should back up. So we have 4 of our 5 AMAs that are basically a safe yield AMA. Prescott, Phoenix, and Tucson are defined as, their management goal is defined as achieving safe yield by 2025, achieving and thereafter maintaining. The Santa Cruz AMA was assumed to already have been at safe yield when it was established as an AMA. So their goal is to maintain safe yield and to prevent local water tables from declining. The Pinal AMA has a very different goal that works to balance the development of non-irrigation uses with the preservation of existing agricultural uses. So that's a unique AMA and a unique management goal that's established in the statute. Like I said, this might be different for a subsequent AMA because it's not established in the statute and there would be a development process for a subsequent AMA. For management plans for the initial AMAs, again, you can see that we have that noted on the slide. The details of conservation programs are contained in the management plans. So the design of the management plans is to be the location, the place where the details of those conservation programs is held. And the purpose of the management plan is to have those conservation programs, which are designed to reduce withdrawals of groundwater in order to move an AMA toward its goal. So we have specific statutory requirements for those initial AMAs regarding the management plans and the series of management plans. There is a series of 5 management plans laid out for the initial AMAs. Again, this could be different for a new AMA and is something that would be provided for in the development process of that first management plan. In the existing AMAs, the management plans, like I said, provide the details for the conservation requirements for water users in that AMA. The existing management plans split up those conservation programs into 3 sectors: agriculture, municipal, and industrial. The chapters and the programs that are contained in those chapters provide all of the details of those requirements. So the statute lays out the framework and the management plan builds out all of the details of how those various users are to comply with their conservation requirements. So it includes the details of the actual requirement. It includes reporting requirements. It includes calculation methods for user-specific targets. It includes any flexibility provisions and also compliance provisions. So I know there's a lot on this slide, so I'll spend a minute here. We're switching now to how this would function in a new AMA. How would a management plan and a management goal be developed and adopted in a subsequent AMA? So very basically here, ADWR would propose a management goal for the new AMA and a number of years in which that goal was to be achieved. ADWR would also work with stakeholders to develop a management plan or a series of management plans containing those conservation programs that I talked about on the last slide. ADWR would appoint an AMA director, and the governor would appoint GUAC members to advise the ADWR director on the AMA and the conservation programs for that AMA. GUAC, I apologize, I skipped over that acronym. I know there's a lot of acronyms here. GUAC stands for Groundwater Users Advisory Council. So a GUAC has members, 5 members, who are chosen to represent users of groundwater in the AMA on the basis of their knowledge of, interest in, and experience with problems relating to the development, use, and conservation of water. That's a statutory definition, and that's something that we establish in each AMA. Excuse me. Like I said, we would propose a management goal, we would work with stakeholders to develop a management plan, an AMA director and a GUAC would be appointed, and finally, a public hearing would be held on the management goal and the management plan, allowing time for comments from the public, from any interested party, after which the goal and the plan could then be formally adopted. So, who would be allowed to use groundwater in a new AMA? There are 2 categories of wells in an active management area. Exempt wells, very generally, an exempt well is a smaller well. An exempt well is a well having a pump capacity of 35 gallons per minute or less. And with an exempt well, a person can withdraw groundwater for a non-irrigation use. Again, our very specific definition of irrigation here being greater than 2 acres. So a person may withdraw groundwater for a non-irrigation use using a well with a pump capacity of 35 gallons per minute or less, without a right or permit. So exempt wells are just what they sound like. They are exempt from having metering and reporting requirements, and they are not required to have a groundwater permit in order to continue pumping. Many times these are things like domestic wells, they might be stock watering wells, those types of things. There are some limitations on exempt wells. Only one exempt well may be used to serve the same use at the same location. And withdrawals from exempt wells for a non-irrigation purpose other than domestic use and stock watering are limited to 10 acre-feet per year. So those might be commercial uses or other types of non-irrigation uses. Non-exempt wells are all of the other wells. So within an AMA, a person may withdraw groundwater from a well having a pump with a capacity greater than 35 gallons per minute only if the person holds a right or permit to withdraw that groundwater. And that's important. We'll talk a little bit about an application process to obtain a right or permit a little bit later. Actually, right now, just kidding. Sorry about that. So there is an application required to obtain a right or a permit to use groundwater. There are a number of different types of permits, and we're going to cover a number of those in this slide and the coming slides. The most frequent type of groundwater right that we see is grandfathered rights. So I'll talk through kind of the different types of grandfathered rights, but there are also additional rights that are not grandfathered rights that are allowed in an AMA. So we'll talk through those as well.
I would just note here that we have had some folks come to us and ask, can I start making an application now? Can I submit to you evidence that I've been irrigating? And the answer to that question is no. Unless and until there's an AMA, we wouldn't be accepting applications for certificates of grandfather right. If an AMA is designated, the department would provide notice to folks throughout the basin of the obligation to file an application, and those applications would be made available on our webpage. So I just wanted to clarify that one point. There's been a little bit of confusion about that.
The other thing that is really important to note there regarding the applications is that there is a requirement in statute that folks apply not later than 15 months after the date of the designation of the AMA. So there is a deadline on that we do not have flexibility around. Maybe, yeah. In any case, there's a deadline around that. So the application must be submitted to the department not later than 15 months after the date of the designation of the active management area. So we'll move through the various types of grandfathered rights. A couple things to note here is that there is an irrigation grandfathered right that we often refer to as an IGFR. And that is, again, specific to that very specific definition of irrigation that we have, greater than 2 acres. So we have IGFRs, irrigation grandfathered rights, and then we have 2 different types of non-irrigation grandfathered rights. Type 2s are a non-irrigation right created based on non-irrigation pumping that occurred in the 5 years preceding the designation of an IMA. So if there's a non-irrigation use that's occurring now, that would theoretically be something that someone could apply for a type 2 for. Type 2s are really flexible. I'll talk about those in a few more minutes. Type 1s are created from the permanent retirement of an IGFR, an irrigation right, and are, again, for non-irrigation purposes. And those are limited to 3 acre-feet per acre and maybe less than that. So irrigation grandfathered rights, IGFRs. IGFRs allow the right holder to irrigate those acres of land that had been irrigated within a 5-year time period preceding the call for election. That first bullet point there is important because this type of right is tied to the land. So the water use associated with an IGFR is limited to those acres that we refer to as irrigation acres, those acres of land that have been irrigated in that 5-year period. Land without an IGFR may not be irrigated with groundwater. So that's another important thing. An irrigation grandfathered right, again, is tied to the land. So if the land or any part of the land is sold, the right is sold with the land. The irrigation grandfathered right cannot be sold apart from the associated land.
Okay, so as I had discussed previously, with respect to which acres of land may be irrigated if an AMA is designated, there is a provision that provides that land will have been deemed to have been irrigated within the 5-year period preceding the call. I want to be careful here because it actually differs depending on where we are. So I'm just going to be very careful. I'm going to read my slide. If an AMA is created, property owners who believe that they qualify for consideration of substantial capital investment may apply to DWR, and DWR will evaluate each application on a case-by-case basis. So I would note that the time that folks would make an application based on substantial capital investment would be at the time that they're applying to the department for a certificate of grandfathered right. So what I mentioned previously about people have asked us questions, can I send you receipts? Can I send you information now to show that I've made a substantial capital investment towards irrigating my land? And the answer to that is no, we are not currently accepting that information unless and until there is an AMA designated. There is no mechanism for us to even process that or review those types of applications. And frankly, unless an AMA is designated, it's sort of a moot point. So what does get a little bit tricky here is in statute, in terms of defining substantial capital investment, the provisions are a little bit different depending on whether or not you are, the acres are currently within an irrigation non-expansion area or not. So for an area that was not previously an INA, so this would include land within the Willcox groundwater basin, and it would include those portions of the Douglas groundwater basin that are not within the Douglas INA. Acres of land will be deemed to have been in irrigation if substantial capital investment was made within the 5-year period preceding the call for the election. For the subjugation of such land for an irrigation use, including on-site distribution facilities and a well or wells, the drilling and construction of which were substantially commenced before the date of the call for the election. Now, you'll notice that's different if you were talking about an area that is currently within an INA. Acres of land will be deemed to have been irrigated if the director finds that substantial capital investment has been made in the 12 months before the date of the call for the election. So that's one point of distinction. If you're in an INA, substantial capital investment will only be considered to have been made if it was made within the 12-month period preceding the call for the election in an INA. And also, you'll notice the language is slightly different here. Call for the election for the improvement of the land and on-site irrigation distribution facilities, including the drilling of wells for an irrigation use. So I know that this is sort of this is one of many of sort of big questions that we've been receiving. If I'm doing X, Y, and Z, can you tell me, is that going to qualify me for a grandfathered right? Am I going to be grandfathered in if I do this, this, and this? And I know that this is not a satisfying answer, but we cannot make sort of predeterminations about whether or not something is going to satisfy substantial capital investment. There's a number of reasons why that's the case. One is because it is fact intensive. When we actually, if we're called to review these applications, they will go through a formal review process. There will likely be multiple layers of review. And we simply, can't tell people ahead of time based on informal conversations or even partial submissions of information, yes, no. And then when the time comes for a formal application to be made, we learn new facts, or we fulfilled the formal review and we have more information. We just can't get into making those kinds of predeterminations for folks. I know that again, like I said, that is an area where people have been asking us for certainty. What we have done on our website is we have provided links to substantial capital investment documents that we have reviewed in the past, because substantial capital investment has been considered by the department in connection with the creation of the initial AMAs. So there is a little bit of precedent there, and we've tried to provide links. We have provided links on our webpage for folks to go, and you can actually see some examples of applications that were made in the past for substantial capital investment. I do want to make one major caveat for folks who are going to the webpage to look at that. The statutes, and this gets a little bit confusing, but the statutes that applied at the time to substantial capital investment in the initial AMAs, they contain language like that kind of mirrors the language that we have for subsequent AMAs. And they're actually, just like you see here, there are two different provisions. One that has to do with lands that were previously in areas that were called critical groundwater areas. We no longer have critical groundwater areas in the state, but at the time of the creation of the initial AMAs, there were some areas of the state that were designated as critical groundwater areas. So I would just caution folks that as you're looking at those past examples, you might try to pay attention to see whether or not the same standard applies as what would apply in your case. And here's where I would come back to the suggestion strongly that folks who have concern about whether or not investments that they're going to make are going to qualify. You know, obviously this is a personal choice for everybody, but I would advise folks to consult with their own legal counsel, because we can't provide you legal advice. We can't tell you you should go out and apply water. We can't tell you any of those things. So if that is something that is of concern, we would urge you to seek out your own legal counsel.
The other thing that I would note associated with irrigation acres, is that in the irrigation non-expansion area, so in the Douglas INA, the 5-year irrigation requirement does still apply there. So there are already withdrawal authorities for specific lands there, but just because land in the Douglas INA has a current withdrawal authority does not mean that they will automatically be provided a grandfathered right. They still need to show that 5-year irrigation history in order to, in order to apply for an irrigation grandfathered right if that area were to be established as an AMA. So what we'll go into next is, again, I know a lot of this is really dense, and this is something that will continue to be a little bit dense. So what we're going to talk about now is how irrigation water duties and allotments are established in those initial AMAs. I really want to emphasize on this point that this may be different for a subsequent AMA because it is a formula that is established as a part of the management plan. So the stakeholder discussion process that we would have as a part of the development of a management plan in a subsequent AMA would be an opportunity for folks to have some input on this precise calculation. So this calculation that I'll be talking through here is specific to the initial AMAs and how this is calculated for their management plans. The calculations include the basic function or the basic formula for calculating an irrigation water duty is irrigation requirement divided by assigned irrigation efficiency. I'm going to define each of those things. So water duty is an acre foot per acre number. The irrigation requirement is made up of several different pieces. It's consumptive use plus a leaching allotment plus other needs minus effective precipitation. Consumptive use is a value, again, established in the management plan, but typically what we've done in the past for consumptive use is referred to scientific literature for the area where the AMA is to better understand what the consumptive use of a given crop is. A leaching allowance, again, is a formula based on soil or water salinity. Other needs can be things like germination requirements. There's a little bit of flexibility with the other needs requirement, but again, that's established for each crop as a part of the management plan. And then effective precipitation may be subtracted out. Currently in the existing AMAs, we only subtract out effective precipitation in the Prescott active management area. But again, that would be established as a part of the management plan. So going back to that initial formula, water duty is irrigation requirement. So all of those things, consumptive use plus leaching allowance plus other needs minus effective precipitation makes up your irrigation requirement. Irrigation requirement divided by assigned irrigation efficiency. Assigned irrigation efficiency is not the same as actual on-field irrigation efficiency. In the existing AMAs, the default assigned irrigation efficiency is 80%, and it's actually capped at 80% for those AMAs. So it can't go higher than 80% in this formula. In some cases, the assigned irrigation efficiency can be lower than 80% if there are specific limiting conditions that exist, like sandy soils or significantly sloped fields. So like I said, the water duty is an acre foot per acre number, and we use that acre foot per acre number to get us to a total allotment for the farm. So we multiply the acre foot per acre number by water duty acres. So we've talked about irrigation acres already, which is the kind of full footprint of any acres irrigated in the 5 years prior to the call for election. The water duty acres are distinct from that in that it is the highest number of acres irrigated in any single year of that 5-year period. So that's a subtle difference. The difference being that irrigation acres is the total number of acres irrigated at any time. Water duty acres are the highest number of acres irrigated in any single year. So if there are crop rotations or fallowing or anything like that, the water duty acres may be lower than the irrigation acres. Often they're the same, sometimes they're not. So the total allotment is calculated by multiplying water duty times water duty acres. And that provides a total allotment for that farm. So that is the amount of water that can be used by that IGFR in a given year, irrigation grandfathered right, IGFR, in a given year, subject to flexibility provisions. There we go. Okay. So, oops, there we go. So next we'll talk about non-irrigation grandfathered rights, and the rest of this hopefully will go a little more quickly. I understand that there's a lot of information here. So again, we have a type 1 non-irrigation grandfathered right. A non-irrigation grandfathered right is a type of non-irrigation grandfathered right that is tied to the land. So this is associated with land that has been permanently retired from farming and has converted to a non-irrigation use. So this right can only be used for non-irrigation uses. Since this right is tied to the land, it can only be conveyed with the land. So if the land is sold, the right is sold. The maximum amount, the maximum volume associated with this type of right is 3 acre-feet per acre, and it may be less than that depending on prior uses. A type 2 non-irrigation right is more flexible than that. So again, this is a non-irrigation grandfathered right. This may only be used for non-irrigation uses. This right is based on historical pumping of groundwater for a non-irrigation use. Type 2 rights are flexible because they are not tied to the land. They can be sold separately from the land or the well, and they can be used anywhere within the AMA. They can be used anywhere within the AMA, or you can change the point of withdrawal subject to ADWR approval. It is possible to lease a portion of a type 2. But if the right is sold, the right must be sold in its entirety. If it's sold in its entirety, it cannot be split when sold. In addition to grandfathered rights, there are also other types of withdrawal authorities in the active management areas. These additional types of withdrawal permits are for non-irrigation uses. Typically, these are temporary approval, not necessarily short-term, but time-limited, most often for industrial uses. So we have a list of the types of withdrawal permits on the right-hand side of the slide here. Hydrologic testing, poor quality groundwater permits, temporary electrical energy generation permits for emergency situations, mineral extraction, drainage and dewatering, and general industrial use permits. So those are all non-grandfathered permits that can be established after the creation of an AMA. And then, another type of non-grandfathered right is a service area right. So a service area right is the right for a city, town, or private water company or irrigation district to withdraw groundwater for delivery to customers in its service area. So this type of withdrawal authority is based on the connections to the service area, and the right can expand as the service area expands. This type of right provides a withdrawal authority to serve customers. Most often, this is for municipal types of uses. This service area right can be subject to conservation requirements in the management plan if it meets specific thresholds for the size of the municipal provider or things like that.
I'm going to talk a little bit about the adequate water supply, which currently supply program, which is currently administered outside of the AMAs, and then the assured water supply program, which is administered within AMAs, and a little bit about the difference. So both Cochise County and Graham County are currently subject to adequate supply program, adequate water supply program that applies outside of AMAs, as I mentioned. A developer of a proposed subdivision must obtain from ADWR a report on the adequacy of the water supply for 100 years before, I guess what I should say is, there are certain jurisdictions outside of the AMAs that have adopted what's known as mandatory adequacy. And in those cases, Cochise County as an example, they have an ordinance that requires an adequate water supply in order for plat approval. Sorry, I'm getting a little bit of static here. Can we define? Oh no, sorry, there's an annotation. Oh, that's okay. In areas that have not adopted mandatory adequacy, plats can be approved if even if the department determines that a water supply is inadequate. However, the inadequate water supply has to be disclosed to the first buyer. Under the assured water supply program, a developer of a proposed subdivision, so someone who proposes to divide 6 lots or more must demonstrate a 100-year assured water supply in order to obtain plat approval and offer lots for sale. There's 2 ways that a developer can do that. They can obtain a commitment of water service from a water provider that has been designated as having an assured water supply, or they can obtain a certificate of assured water supply by ADWR, demonstrating that the subdivision will have 100 years of assured water supply. The requirements under the assured water supply program is a demonstration of physical, legal, and continuous availability for 100 years to serve the proposed subdivision, financial capability, to serve the subdivision in adequate water quality. Those requirements substantially are the same in the adequate water supply program. There can be some differences in how the physical availability of water is evaluated within areas outside of AMAs. However, for assured water supply within AMAs, in order to obtain a certificate of assured water supply, the developer has to show additionally consistency that the development would be service of the development would be consistent with the management plan and the management goal. So obviously outside of AMAs where there are no management plans and there are no management goals, that requirement does not apply. So those requirements would be new requirements that would come into effect if a new AMA is designated for purposes of development. Okay, and then I'm going to try to move quickly because we are getting short on time. I know that there are folks who have questions. Measuring and reporting, with a few narrow exceptions, persons withdrawing groundwater from non-exempt wells are required to measure their groundwater withdrawals with a measuring device and method that is approved by ADWR and must report the groundwater withdrawals to ADWR. Annual reports are due March 31st of each year. Requirements for measuring devices, we currently have those in rule. If folks, they're partially in statute and partially in rule. So if folks are interested in seeing currently what methods and what devices the department approves for measuring devices, the references here will point you to those rules. A person withdrawing groundwater from an exempt well, remember that's a well having a pump with a maximum capacity of 35 gallons per minute or less that are being pumped for a non-irrigation use. Those generally are not required to measure and report groundwater withdrawals. Now, Natalie mentioned this before, that throughout the state, we have, there are requirements regarding well drilling, registration, and construction. Those apply regardless of where you are in the state. So many of those will not change. So before drilling, deeping, or replacing a well, a person must file a notice of intent to drill with ADWR and obtain a drilling card. The well must be drilled by a licensed well driller, and the well must be constructed in compliance with ADWR's well construction standards. For exempt wells, impacts on other wells are not considered. Inside AMAs, non-exempt wells may be subject to well spacing requirements. So in order to drill a new non-exempt well in AMA, someone has to apply for a permit, and the permit would be denied if the proposed well would cause unreasonably increasing damage to surrounding land and other water users. And DWR has adopted rules defining what is unreasonably increasing damage.
All right, so we made it through all of that. I'm going to pause for just a minute to check in about the number of speaker cards that we have. So we will be back in just a moment and we'll start calling the first speakers. If you have any questions and you have not yet filled out a speaker card, additional speaker cards, I think can still be found on the sign-in table. A few of them are left still. Speaker cards can be found at the sign-in table. We will ask that folks come to the podium up front, and we'll hopefully provide a microphone or something so you can ask your questions so folks on the webinar can hear. And we will call people up in the order that we receive speaker cards, kind of alternating between our online and in-person participants. So give us just a moment here and we will start back up by calling up our speakers.
Oh, I can. So I might take that. Should I reiterate?
Okay, I think we're ready to go ahead and get started with questions. Just a friendly reminder, please limit your questions to the topic of our presentation. Please refrain from making commentary for or against the designation of the AMA. I know some of you all are sneaky and will maybe try to shape your questions as a form of a comment. No, nobody would do that, right? We would just ask that you would please just keep your comments to questions. I know that doesn't make sense, but please just ask questions that are relevant to the topic, and please try to avoid advocating through the questions if you wouldn't mind. Please, and I know I don't need to repeat this, but if we want to try to get to as many people's questions as we can. So if you could try to limit it to 1 or 2 questions, we hope to be able to get to everybody's questions. And if there's time at the end for people to come back, we would be happy to try to answer those questions at the time, but try to be respectful of other people's ability to get up and ask their questions too. And we are hoping to, I think we're planning on ending today's meeting at 8. I know we got off to a little bit of a late start. But again, if we can try to keep it to 1 or 2 questions per person, hopefully we can get to as many people as we can. I believe that we're going to be calling up names, and we'll ask you to come forward to the podium if you would. We'll hand you the microphone, And we'd ask too that you address your questions to us, not to anybody else in the room. If you could just address your questions to Natalie or I, that would be great.
What I'm gonna do is I'm gonna call two names at a time, just so that the second person can be prepared to come up to the podium after the first person is done. We'll hopefully be able to get through more speakers that way and feel prepared to come up to the podium one after another. So our first two speakers, first we have Randy Redhawk, and after him will be Alan Seitz.
I do have a question, but I have about a minute worth of history here I think that everybody should know about. A few years ago, I filed an AMA and I got a lot of,
Finally breaking up.
I know, but please bear with me, but I think it's relevant.
Yeah, I know it is relevant, but I know we have a lot of people
I'd be very brief. I do have a question. So I was approached by all these people and the stakeholders. After our second meeting, we sat together and handed out for a whole year, a piece of legislation bill. And at those meetings, Gail Griffith and Dave Stevens, our representatives, were there. This bill, it was brought up to Phoenix, and we got nobody to sponsor that bill, including Gail Griffith standing right over there. So my question is, and that document that we came up with, I would like to see that go into this new AMA if it comes to fruition. And my question is there enough power of the AMA to include industrial? Question.
Thank you. So there are industrial uses allowed under an active management area. Often they use the non-irrigation types of rights that we talked through earlier. In the management plan, there are conservation requirements for industrial users. So there are different categories of industrial users. As we've caveated over and over again throughout this presentation, obviously the management plans might look a little bit different under a subsequent AMA. That management plan would have to be developed for a new AMA. So the precise requirements that those industrial users would be subject to would have to be developed as a part of that management plan process. But there are there is a precedent, there is some history there related to conservation requirements for industrial users, as well as municipal and agricultural users.
Yes, and just to clarify on that point, so industrial users could not use use groundwater unless it was pursuant to a right or authority if they're being served from a non-exempt well. So I just clarify that in a name.
You can stay up there, Ellen, sorry. After Alan, so Alan Seitz is our next speaker. After him will be Sonia Gasha.
First of all, thank you very much for your time and all the information that y'all put forward. My question is, if an AMA is passed and there are management plans developed, which that's what you're tasked to do, do you take in the effect on the local economy? Does that come in the equation as far as whether you're looking at managed depletion, say field, or what other options there would be out there? How's that decided?
So look, that's a great question. I would say that to the extent that sort of the unique features of the basin and the economy, those would be sort of considered in connection with development of the management plans and development of the management goal. And as Natalie just sort of highlighted in her, in her slides that she presented, there will be opportunities for stakeholders in connection with the development of those proposed plans and then in the public hearing process for the adoption of the management goal management.
Right, Sonia Gasho is our next speaker, and after her will be Chris Upchurch.
Good evening. Thank you all for coming. I have a couple of questions. The first is a clarification. I appreciate your definition of irrigation. If I have irrigated pasture or I'm growing crops for the farmer's market and I'm less than 10 acres, say, or 15, but I have an exempt well, less than 35 gallons a minute, under these definitions, I would still have to have an irrigation right, correct?
Yes, that's correct.
Thank you. And my second question is, if either one or both of these proposed AMAs is enacted, what implications does that bring for interbasin transfers or sale of water to municipalities?
Could I have you come back up? I think what I would have you do, because the groundwater code does contain provisions related to transportation, but I want to make sure that I'm understanding your question. And then also, I might not be able to answer it for you as I sit here, but if I have it as written down, I might be able to follow up with you. Okay. So I'm going to have you ask that.
Okay, so what I'm wanting to know is, right now, without an AMA, it's the way I understand it, water use is on a beneficial level. And their interbasin transfer is not allowed. If an area is designated as an active management area, I want to know if that opens the door for interbasin transfer or sale of water.
Okay, I think I understand your question, and I think I am going to have to go back and look and read the statute about the effect of the designation of AMA on the transportation rules. I'm sorry. So I'll take that back, and then we have your information on the speaker card, so we hopefully. And I should say, someone came up to me before the question period. And said, you know, what if we don't have time? You don't have time to get to our question, that type of thing. Natalie will have her email address. You're welcome to send additional questions to her email address. If there are questions that we see we're getting a lot of, and we feel it might be appropriate to update our FAQ, we will do that. If it's something that we think we can provide just sort of general information to you, again, remembering that we can't provide legal advice. We hopefully can try to reach out to you and answer your specific question if we can't get you tonight.
So next up, we have Chris Upchurch, and after him will be Nathan Watkins, or after her, excuse me, Nathan Watkins.
Okay, I've been reading that the Douglas Water Basin goes into Mexico. Is that correct? And how do you regulate that?
So our jurisdiction is for the portion of the Douglas Basin that is in Arizona. We don't have any authority outside of the state of Arizona.
You could, and if you could tell me how many acres are irrigated in the Douglas Basin?
I don't have that number in front of me. I think that's something that we could follow up with you and provide for you. All right, next up we have Nathan Watkins, and afterwards comes Tina Thompson.
Again, thank you for coming. Short notice on us, call for elections in 2 weeks. So we don't have
Okay, I think we're reconnected now. Apologies for the technical issues here. Okay, so I think we're reconnected now. Hopefully those of you on the webinar are able to hear at this point. Just a reminder to those of you on the webinar, we'll make sure to put the virtual speaker card in the chat box. Excuse me, in the chat box again. If you are on the webinar and would like to make a comment, please do submit that virtual speaker card and we will call your name when it's your turn. Okay, so our next speaker was Robert Carlson III, but I understand that he may have left. All right, I'm getting some nods. So next up we have Rod Keeling, and after him will be Bernard H. Brunner.
Thank you all for coming tonight. We appreciate it. My name is Rod Keeling. I have Keeling Shaver Vineyards with my wife, Jen Shaver. The question I have tonight is, has a little bit of background. My brother's farmed my dad's farm in Casa Grande since 1928. Resources of water, groundwater, Colorado River water, and Gila water from the San Carlos. So when you guys got up here, the main question I have is when we talked about how the existing irrigators would receive their grandfathered rights and how those rights would be determined and what volume. You had a formula up there, and we talked about the 80%. And so I just wanted to know if I got this right, that approximately 80% of the historic use, or up to 80% of the historic use, will be awarded for future use for those that have grandfather rights. Is that correct?
I can clarify that. So the 80% number was the assigned irrigation efficiency. So what we look at is that kind of irrigation requirement formula, consumptive use, and all those other things, divided by the assigned irrigation efficiency. So when so you divide by 0.8 in that example, and that actually produces a sorry about that. That actually produces a higher water duty than it would have been based on 100%. So it's kind of an inverse thing. The 80% irrigation efficiency actually is higher than 100%.
And I just wanted to clarify, that is what how the allotments are initial AMA. And this calculation allotment is dependent on what is contained in the management plan. There is no, we can't provide any kind of assurance that that is how we calculated for purposes of a new AMA. It would be dependent in part on the management plans, which are adopted after the designation of an AMA with the input of the Groundwater Users Advisory Council, the area director, the public hearing process. So I just wanted to make that clear.
So just to get it down in English for just a moment, are the current irrigators going to be awarded water rights that are significantly less than the water rights they have, the water they're using today or the last 5 years?
In the existing AMAs, the water duties and allotments were based on the crops historically grown. It wasn't based on historical water use. So what that assumes is growing those crops with a reasonable, potentially 80% irrigation efficiency. Again, for the existing AMAs, and it could be different under an AMA. Thank you. All right, next speaker is Bernard H. Brunner, and after him will be Mark Spencer.
It's comforting to know that you folks are neutral. And it's a perimeter. I have about, I get that later. I'll get it. About 1 million questions, but I'm going to walk it down to one. It concerns exempt wells, either to be deepened or new wells drilled. Okay, for non-irrigation purpose, somebody wants to build a home on land they bought, they need a domestic well, or they need to replace, deepen an existing well, either domestic, or they need to drill a new well or keep out in the rain. And the question is, does the department and an AMA, Department of Water Resources, have the authority, not would they do it, but would they have the authority to deny that person permission to drill those wells?
For an exempt well, you said?
Exempt.
Exempt. So the well permit requirements are in the area.
The last 79-year-old driller without having.
The well drilling requirements are certainly not my area of expertise. But for exempt wells specifically, the requirements and information required at an AMA is functionally the same as outside of an AMA. Because those requirements related to exempt wells apply statewide.
Yeah, so there are some additional restrictions on the drilling of exempt wells within AMAs that do not apply outside of AMAs. Off the top of my head, one of them is it's getting late. It can't be drilled within 100 feet of the distribution system of its designated water provider. So provider has a designation of insured water supply. There are other limitations on the use of exempt wells. So I think what I would, because I think I'm missing something. I think what we'll try to do for this specific question is, have you been on our webpage, or do you have access to our? Do you have an email address? Okay. All right, well, I will work on, I will work on updating that FAQ for everyone else. I think that's probably something that's worthwhile to make sure.
Yes, everybody behind you, at least in this room, we're all in this together. One source of water, and that's the water underneath our feet. So what we do is important. And it's correct. Can you tell me, is it true that the current plans, the time the goal, something like 50 years? 1980 to 2025.
So the statutes for the initial AMAs defined management periods spanning from 1980 to 2025. Right. So because this would be not an initial AMA, because this would be a subsequent AMA, the statutes for a subsequent AMA allow the director to develop the management plan and define whether there may be additional management plans or periods after that. So that would be something that would be established as a part of the development process for the management plan.
Thank you. That's a good answer, I think. Truth answer. So we don't know, but as it exists, it's taken 45 years. So, my second question is this: on your website, I've read, according to the report issued in 2018, that we are pumping somewhere between 4 to 8 times our annual recharge in our Willcox basin. There's no number for the Douglas basin, and that the result of that is, of course, that we can declare about the sinking valley in the state. Is that still true? And if we don't have an AMA, because that causes trouble for all of us, is there any other statutory relief that we can see at this time?
So again, we're not here presenting on hydrology. We do have the links that provides hydrology. I want to be careful in responding to the question to make sure that I reiterate that we're here as a neutral. We're here to try to provide objective information for folks about the sort of the process, the designation process, and then what potentially the department might do in order to administer anything after. So with that, I think probably we probably don't have an answer.
Up next, we have Stella Brown, and after that is Steve Cuso.
If the AMA is passed, and I'm in an IMA, I'm in the Douglas Basin, will it provide for new or enhanced methods of increasing the water supply in the basin? Examples could be delivery infrastructure or major recharge projects to capture runoff. And recharge.
So I would just say that just to kind of keep the discussion confined to what we're presenting here, the features of an AMA are sort of broadly what we've covered here. So I guess I should say there are additional provisions related to recharge recovery within AMAs. However, I don't necessarily think that's probably the question that was being asked. So I guess I would just say that just speaking generally throughout the state, there may be opportunities for sort of of the regulations that come into being by virtue of the designation of active management area.
Up next is Steve Hiesel, and after that we have Heather Floyd.
Hello, I'm Steve Kittle, Groundwater. Couple of suggestions, and I'll get my questions, but one suggestion is it would be very helpful to have a response to a hydrologist analysis report on what's happening here in both the Willcox and Douglas Basin. It would help provide context for what we're going to be voting on, why we potentially want to vote yes or no. Knowing all the rules and how to, I certainly appreciate your attempt to do that, and I know how difficult it's been. But your hands are tied too. The other suggestion would be, besides the hydrologist, is have some folks that would be able to tell us more about the actual experiences in Tucson, and their Cochise County AMAs. I know they're not identical to our situation here, and we certainly know the subsequent AMAs are going to be different. However, there's a lot of people that want answers to some of these questions and at least some insight. We're not going to get it. We may not get the definitive answer. You can't, from a legal standpoint, guarantee. But we need to hear from people who have experienced some of this and they can give us more of that help in understanding this in more detail. I have two specific questions. One has to do with the goal. And I know that the director is required within 30 days, but I understand there will be a long period after that with public hearings. I understand you can have a public call for public hearings within 30 days, so there's no way that could happen within the 30-day requirement. So there clearly will be a public process for the goal, but are there not in fact some guidance in the actual statute in terms of how the goal, what the goal should be or potentially should be within, as far as what the ADWR director will suggest?
I think that we could, we could potentially look to other goals as sort of a way of trying to approximate what we think the legislature intended in terms of what goals should look like. But beyond that, no, there's not there's not a clear statute that if, there such and such is happening in a basin, the goal should be X. If such and such is happening in a basin, the goal should be Y. There's not a directive like that in the statute.
The statute for subsequent AMAs indicates, so the language is the director shall establish a given goal for the active management area and the number of years in which the goal is to be achieved.
That there was also some provision that I think needs to be considered. For the state deal. My other question has to do with the substantial capital investments. Any of us who live here full time and spend time on the roads between here and from Graham, basically Mount Graham's all the way down the Mexican border, certainly have seen the free for all in terms of well drilling in the last few months in anticipation of the AMAs being passed. So there's a lot of speculative, maybe not so speculative, activity out there to establish some kind of substantial capital investment. My question is there anything in the statute or any guidance in terms of how much irrigation they will be allowed, since they will not have any history, and the fact that they come in at the last minute to take advantage of what they could do before, if and when this passes?
Yeah, so I think that that's a question that the department will have to make a determination on, in terms of how to quantify that, sort of at the time.
This question, will there be a public hearing?
Or
Those determinations, is that a public process or is that a private process between the landowner and ADWR?
The application for certificate of grandfathered right is reviewed by the department. There's not a public hearing process. I would have to check to see whether there's an opportunity for folks to file objections.
Specifically on the substantial capital investment.
It would be part of the application for certificate of grandfathered right.
Can you get us an answer?
In terms of whether or not there's an ability to file an objection?
Yeah.
Sure, yes, I can find an answer to that.
All right, next up we have Heather Floyd, and that will be Sandra Clark.
Hi, thank you very much for the opportunity to ask a question. In 2015, there was a lot of discussion about AMAs in this area. AWR did a study that actually implemented the AMA, and at that time it was seen that we were ineligible for one. Can you talk to why it was ineligible and that maybe there isn't a need? I don't want to put words in your mouth, but apparently at that time there wasn't a need based on the study.
Oh, I'm sorry. I'm going to return the mic to you. Was the question about the petition for an IMA in the San Simon subbasin or San Simon?
There was also a study done in this case, to my understanding.
So there has no, to my knowledge, has never been a petition to, either to hold an election or to, for the record, to designate seniors, either an INA or an AMA in the Willcox space.
So
So that was by irrigation users on the subbasin to INA. On the criteria for designation of an INA is different than for the designation. It has to do with whether or not there is a reasonably safe supply of water for the cultivated lands and the current rates of withdrawal. And so at the time that petition, did some groundwater modeling and determined that there was in fact a reasonably safe supply for irrigation within the San Simon subbasin. That was a different, as I said, it was for an INA, which had different criteria than for an AMA, but that's.
I wasn't personally a part of that, and I don't think it's this issue right now.
We want to be advocating position in terms of whether one is like together or not. If people are interested in this, I think as well.
So our election's going to take place, and we're going to vote on whether we're going to implement an AMA. But we don't know what that AMA is going to look like. So we're essentially asked to vote on something that we don't know the goals. We don't know the mechanisms on how we're going to reach those goals. Is that correct?
So what we're trying to do here today is to provide the information that we can provide to everybody. I guess we would just really ask that folks try to refrain from making advocacy in favor or against the position. We are here to provide the information that we can provide.
So we're going to have information prior to the selection on what the goals are going to be for this AMA. We're going to have information to make a following vote. That's what I'm asking.
So the department, ADWR, cannot adopt a goal unless and until an AMA is designated and it receives the input of the UAC. It holds a public hearing on what the goal is and receives input from the area director that's appointed. So until that happens, the department cannot adopt a goal for the AMA.
I think in the interest of time, we're going to go on to the next person. Thank you. All right, next up we have Sandra Clark, and after that will be Jim Brown.
Hi, everybody. Thank you for doing this. I have to say I'm a lay person, and this was a very technical presentation, and I commend you for it. I would have preferred a very simple presentation. These are the pros, this is what's good, this is what's bad about it. So simple people like me could make a decision. But I do have a question. I have two questions. One of them is I'm confused why the people who use the most water, the biggest consumers, I'll call them vultures, really. They don't want an MAA. Why? Why that is? What's the fear? Because when you listen to the news, everyone, on NBC, CBS, whatever, we read the papers, not just local papers. People are alarmed about water running out, being without water, which is the source of life. And the mayor just said that he's never had that issue from the town. Right here, correctly? And the reason is because people are scared. Not everybody has got $400,000 to dig a deeper well.
I'm sorry, we do need to make sure that we're.
Okay, so can you tell me, do you know how many wells have run dry in Cochise County? We have a count? And also, I would like to know why the opposition to an MAA. Because she can't say exactly what it is, but I'll tell you something that think about it. No one. When a person wants to die, it's drinking.
So unfortunately, we're not able to address sides to for against the sides here. For the question about the number of wells that have gone dry, folks are not required to report to ADWR if a well goes dry. We do have some people who have voluntarily reported that information, but we don't assume that that's comprehensive. So we don't necessarily provide that as a number because we don't really think it's an accurate number. So next we have Gina Brown, and after that is David Brott.
I'm Jim Graham with Floyd Vineyards. I respectfully ask, I'm losing my voice. I respectfully ask about Keeling Gas Sunrise. Jim's got a simple question and straight to the point. If the AMA's passed by itself, this regulatory mechanism inside the AMA, will it stop or mitigate the decline in the water table in the Willcox Basin?
We obviously can't speak to that. In part, that may depend on what the goal is and what the plan is to achieve the goal. So.
Next up, we have David Brott, and after that is Mary Ann K. Parks.
We currently have well permits after August 30th. If it's on land that's already irrigated, are we going to be able to allow to continue?
So if the land is already irrigated, then that land may continue to be irrigated.
If it's on land that is not irrigated, and some back or whatever you want to say. How far along in the drilling process will we be to continue drilling? There's going to be a freeze on it. It's pretty involved. How far do we have to be involved to be able to continue to keep drilling?
First, I would make one clarification with respect to the answer of the first question. So if the acres were legally irrigated during the 5 years, so if somebody is legally irrigating acres, those acres are not going to be eligible for. I just wanted to make sure I wasn't suggesting that was your question, but I wanted to make sure that others in the room kind of understood that is. With respect to the substantial capital investment, I know it's not satisfying. I can't give an answer to people in terms of how far along you have to be before it would be considered to be grandfathered in.
Kind of
enforcement in terms of within an AMA. So where are you located?
So
language. After you.
Yeah, I guess it's located yet, but I don't anticipate given the time between. Is, to see if there are sort of ways to sort of avoid sort of draconian.
Who would we contact for that answer?
So let me just make sure I understand the question. Are you asking if during the freeze?
So if I started a well and I'm 20 feet down, all of a sudden it's August 30th, do I fire all my guys and we just wait for 2 months to come back?
No, the answer will be that during the pendency of that time, we will not give you an answer as to whether or not you are going to be grandfathered in. That's going to be their answer.
Okay.
Thank you. Next person up is Mary Ann Capehart, and after that is Fred Zamora.
Hi again, thank you for coming down and explaining all of these details to us, much appreciated, and everybody present, thank you for being concerned. Since my understanding of the AMA that it has to do with creating conservation plans. So this will reduce use in addition to curbing the expansion of acres that will not be able to be sustained in the future without diminishing access to water to people with smaller wells. My question is, does the ADWR come with expertise regarding farming new technologies, irrigation technologies, and maybe crop substitutions and things like that, that inform the conservation plans for agriculture? I won't go into municipal or industrial, but is that part of something the GWAC recommends? How do these conservation plans, what kind of information and expertise is brought to bear on those plans to help conserve water and use it more efficiently?
So in the past, in the development of the management plans, we have relied very heavily on scientific experts, on experts in the field, on conservation professionals in the field, on folks who ultimately are on the ground doing those types of activities every day and know better than we at the department might know. So we work closely with, we historically have worked closely with stakeholders in the development of those plans, precisely to have that type of expertise informing the development of the conservation requirements. Yeah.
Thank you.
Thank you. Right. Next up is Fred Zamora, and after that is Kathy Shelton. Okay, great. Thank you. Okay. All right. We just had both people pass, so we will move on to Jack Husted, and after that is Cheryl Patterson.
Mayor Senator, appreciate your being here, all of you. Real briefly, was there a differentiation between prior to 5 years and the 5 years most recent? I noticed in one of the slides, I think that there was something that said you had to prove up that you had been irrigating prior to 5 years past. Is that right? Just say yes or no. More questions?
In order to be eligible to irrigate acres, those acres had to have been irrigated in the 5-year period preceding the call.
Preceding.
So if 5-year period before August 30th, if that's when the call occurs.
So if I'm not mistaken, this has never occurred before where a vote has been taken and people have asked for an AMA. So statutorily, does the director and these 5 members gubernatorially appointed board of directors have some flexibility to create the AMA that we want? The AMA that is for this area. You've been talking a lot about what the legislature did, plus the legislature not. But we don't want what they got, and we're not sure we want what this is, because as somebody said, we don't know what this is yet. But does the director have the license, have the capacity to involve this community and create something that's good for everybody?
So I would answer that question just by noting that there are some things within the AMA structure that are sort of non-discretionary. Those are things like the requirement to have a withdrawal authority, a right or a permit in order to use groundwater, for certain uses. And those are not something that the director would have discretion on. Where there is maybe perhaps what you would call some flexibility is with respect to the development of that management plan and the management goal. And we've kind of described the public input process, the hearing process. I want to just be clear in answering that question. In some of these questions, I can sort of hear a little bit of advocacy, and I just wanted people to be clear that when I'm answering these, I'm trying to answer them very objectively, just so folks know that there are some aspects of this that we do have a little bit, the director does have a little bit of discretion, but there are some that we tried to highlight where those were, talk about where the director would not have discretion.
What authority do the 5 gubernatorial appointed board of directors have? What authority do those 5 appointed board of directors, are they figureheads, or do they have some input? And I heard the discussion of an appointment of a manager of the AMA. Is that done by the director, or is that done by a vote of the 5 members of the what did you call it? The GUAG. There you go. I don't think I want to be a member of that. But in any case, what authority do they have, and who is the director? Who is the manager of the AMA?
So the GUAC, Groundwater Users Advisory Council, is an advisory body. So their authority is, their function is to advise the ADWR director on issues related to the active management area, including conservation requirements and that type of thing. The active management area director is also something that's established in the statute, and that is a person that the ADWR director that's someone that he would appoint or that director would appoint. And that's just a person responsible for administering the requirements in the AMA. So right now we have 2 AMA directors. I'm one of them. And the 2 of us are responsible for doing things like this, answering questions about the AMA, but also for managing annual report processes, data analysis, processing permits and conveyances and those types of things. So a lot of the function of that AMA director ends up being kind of on the administrative side.
One more clarification. So the statutes describe the minimum of public involvement. There is nothing to stop the director from going above that with pressure from people. This is very important. Water is as you realize, it's very near and dear because you die without it. So there could be a whole lot more public involvement in the crafting of this AMA, correct?
So I think Natalie mentioned that in connection with the crafting of the plan, it would involve stakeholder input. That actually, now I want to be careful and how I say this. There is a statutory requirement that we hold a public hearing, but that stakeholder involvement that we mentioned is above and beyond what is statutorily required. So I will just say that the director is DWR generally is sensitive to the importance of this issue to people. I mean, obviously it's what we do for a living. We know that water is important to people. We know, how it can impact people's, lives. So nobody at the department, we take that seriously. So I guess I would just say, I think that to the extent that the director has kind of indicated that would be this sort of involvement of stakeholders, I think is an indication that we would recognize that there's more that we could do than what's just in the statute.
Real quickly, is there identified 3 uses for wildlife? Here, there's water going into the playa, which is very important for wildlife.
People
The Arizona Game and Fish puts water into the playa, which is very important. You mentioned the 3: industrial, residential, and irrigation. Where does wildlife fall into that?
We may have to get back to you on that one. There are examples of similar types of things within the AMAs. I'm just not perfectly familiar with the types of water rights used for those functions. So I'd have to follow up on that and check that for you.
We are over time, and I know we've got a late start and we wanted to give people an opportunity to ask questions. It looks like we have maybe 10 or so cards here in the stack. If there are folks who feel like they've had their question answered and would be substantively answered and would be willing to pass, that's helpful. But I think we would probably propose to maybe go to 8:30. And then if we haven't reached everybody's question by then, we would provide you with Natalie's email address and you could provide us your question via email. She might give you a fake number.
So I'm Caleb, I'm the city managers. The city of Willcox will print off any questions that they respond to, and we'll have them at City Hall. So for those of you who don't have email or Facebook or any other ways of communication, you can come by and you can get them, we'll print them off for you to make sure you have that information available.
All right. Next up, we have Cheryl Patterson, and after that is Jackie Watkins. And again, if you all are okay with passing, please do let us know. Cheryl left, okay. Is Jackie Watkins? Thank you. After Jackie will be Ashley Dahlke.
ADWR did the groundwater modeling in the Willcox Basin. Are they going to do the groundwater modeling in the Douglas Basin?
I do not know the answer to that. We obviously limited resources and all, we do try to work through the various basins. What I will say is that under some legislation that was passed this past legislative session that expanded with ADWR is also doing a supply and demand analysis of every basin across the state on a 5-year rotating basis. So Willcox and Douglas would both be covered as a part of that. I don't know whether there will be groundwater modeling associated with those, but there will be additional analyses coming. All right, Ashley Dahlke is up next, and after that I have Ben.
Thank you all for being here today. Community is really important in the Sulphur Springs Valley, and we've heard that touched on throughout the meeting today. But could you say a little bit more about the Groundwater Users Advisory Council? How soon would the governor appoint the council? How long do they serve? How often do they meet? And are these hearings public? And this could be about initial AMAs, right? I mean, I know you might not be able to say it for subsequent, but a little bit more information there.
I'm going to try to put this off the top of my head, but there is a statute related to this. The Groundwater Users Advisory Council, that structure is established in statute. It is 5 members and they are appointed by the governor. So folks can apply to boards and commissions and the governor selects from the applicants who apply to boards and commissions. Each GUAC member serves for 6 years. And the GUAC meetings are required to be public meetings and are subject to open meeting law, meaning that we have specific requirements for agendas and minutes or meeting recordings and that type of thing. There's probably additional details there that I'm missing because I'm failing to find the specific statute right now, but that's a lot of the gist of it.
Real quick, one other question. So when you were talking about spacing requirements for wells, you talked about unreasonably damaging surrounding property. And so I don't know, you said that there was a list available of what exactly that would mean. And I was just kind of curious what that would look like.
So unfortunately, or I are the experts on sort of the well permitting side of things, but those are what is considered to be reasonably. Okay, I'm going to make sure I get the language correctly, so I say it. And my internet also went down, so I'm having difficulty being able to pull it off from the web. Yeah, I'm sorry, I apologize. I thought that we had an FAQ that talked about this, but I'm not finding it now. So I think along with the question that was asked earlier about the drilling of new exempt wells, I think those are probably the types of things that we will want to update our FAQs about. So I apologize for not going to give you an answer off that minute. But those are in our rules. What is the? Oh, the well spacing rules are in our rules. So if you go to the administrative code, to the, Arizona Department of Water Resources rules, there are rules that are about well spacing. They talk about what what those requirements are, and I apologize.
Sorry about that. We will follow up with you. I just wanted to add to the previous question, the reference for the GUAC statute is ARS 45-420. Thanks. Next up, we have Ben. Is Ben still here? Great. And after that, we have Dale Lehman.
Are there requirements about the quality of water counts as assured water in this basin, since we're landlocked? The deeper you go, the saltier it is, and it will follow farmland the deeper you go. So is there a parts per million involved with that? For example, 150 or under 1,000 ppm is drinkable, 40,000 is seawater. At what point does that water become not count as assured water? That's part one. The other is related to this. At what depth of groundwater is considered assured water? Is that 100 feet, 200 feet, 500 feet, 1,000, 2,000, 3,000 feet? The deeper you go, the more money you have to spend to get to it, the more money you have to spend to pump that water out. And the more people's wells run dry. So that's the first question.
So with respect to the Assured Water Supply Program, well, as I mentioned, currently outside of the AMAs, the department administers the Adequate Water Supply Program, and we evaluate whether or not water is physically available for physically, continuously, and legally available for 100 years from a depth to a depth of 1,200 feet below land surface. It varies within other AMAs. When we're talking about the Assured Water Supply for the purposes of physical availability, it varies by the AMA in terms of the depth below land surface that we would consider water to be physically available for 100 years. With respect to water quality, yes, in both the Adequate Water Supply Program that currently is administered outside of AMAs and within AMAs for the Assured Water Supply, there is a water quality component that we analyze. Unfortunately, I'm a little bit hamstrung. I'm having issues with my connectivity, and I was trying to see if I could pull up more specifically how we evaluate specifically that criteria. But there is a water quality component. That is something that I think you could probably access pretty readily on our website, but we would be willing to try to follow up with you specifically about that if you wanted us to.
What is the name of the person who made the decision to not talk about hydrology and the other related aspects that are published on ADWR website, conducted by ADWR staff with Arizona tax money as public record? Who's the name of that person that made that decision?
So, well, I'll let Natalie speak, but I know that Natalie, I'm saying I'm not saying she's the person who made the decision. You know, she and other people in the department have been receiving a lot of questions about specifically the process, about irrigation grandfather rights, how would those be calculated? And we also knew the department kind of became aware that there was some misinformation about sort of the process. So we wanted to come down and give a presentation on that. To be honest, there was never really a thought of coming down to present on hydrology because, as I said, we are and we want to maintain our neutrality on this. So, you know, we weren't coming down to present either way on hydrology. We wanted to let people know the process and what sort of actions the department would take if an AMA was designated.
I think the only thing I would add to that is, obviously, it's very important for us to be neutral. And we wanted to make sure that we were providing information about kind of the statutory structures here. The hydrologic information is available on our website and is available for folks to review and draw their own conclusions from.
Okay, so that question wasn't really answered, but is the hydrology reports conducted by ADWR staff with taxpayer money not neutral, not politically neutral, as it is based on science and measurements of actual real data? Is that not politically neutral? Or is that scientific fact?
So I would just respond by saying it is neutral and it's available for view on our webpage. Our purpose for coming down was to talk about these procedural questions that were cropping up. We were receiving a lot of questions. We tried to answer many of them on our FAQs, but obviously some people don't have access to see those FAQs. Those FAQs were generating more questions. And so our goal was to come down and talk about those aspects that we could answer for folks related to the process.
All right, next up we have Dale Lehman, and after that is Stephen Terrell.
Hi, I'll try to be pretty quick. So you went over a few dates and we may or may not be able to answer this question for me. When discussing land that was irrigated in the preceding 5 years, we're talking just with simple math, August 30th, 2017. We're talking about the day to stop with significant financial investment as a date for the call to election, which would be August 30th of this month, or 2022. For those projects that have been significantly financially commenced, when is the cutoff date? I'm not asking what the number is for what's significant, what's not. When do we have to have that paperwork into you saying, hey, we spent this, we did this? What is the date? So effectively, what is the date of completion that is required to you guys?
So folks who are interested in demonstrating substantial capital investment for purposes of obtaining a certificate of irrigation grandfather right would submit that information to us in connection with the application. And the statute provides, as Natalie suggested, that those applications have to be made within 15 months. If you're received by the department within 15 months after the date of the designation. So that is the date by which, so I guess there's not a completion date necessarily per se with that. It's a deadline by which folks who are seeking to establish substantial capital investment are required to provide their application to us.
Presumably 15 months from November 8th.
Well, and if the county, if it takes them a couple of days to certify the election results, right, then it would be, yeah, that's the date.
We have just a couple more left, so we're going to keep going. Stephen Terrell is up next, and after that is Elaine Bailey.
I want to thank you guys for coming and everything, but it seems like there's still a lot of gray lines within this matter. But one of the questions I have is if a purchase of land was bought with irrigation rights with the intent of using the irrigation rights before the AMA was even talked about, and the closing of the land was during the AMA, what's going on, or everything that's going on. What goes on with the irrigation rights when they bought the land to try to use the irrigation rights? And if this passes August 30th, you can't do anything. What does the guy do who has a loan out on that land he's going to be using for irrigation rights?
So, if the question is, okay, I don't know if this is going to answer the question, but let me know if it doesn't. So someone can only obtain a grandfathered right, an authority to irrigate for acres that have been irrigated within the 5-year period preceding the call. Unless the exception to that is if the person has made a substantial capital investment to subjugate the land for irrigation within a particular period of time. Within an INA, it's 12 months preceding the call. Outside of an INA, it is 5 years.
So with August 30th coming up, then I would still be able to fall within that line, correct? With irrigation.
Yeah, so I might not be following your exact scenario that you're presenting. And again, I don't want to run afoul of, of what we said in terms of we can't give anybody sort of a predetermination. But if the land is currently being irrigated, it would be legally irrigated. It would be eligible for irrigation in the future if an AMA is designated. If it has not been irrigated within the 5 years preceding the call of the election, it may only be eligible if what has been done constitutes a substantial capital investment. And I don't know, are you in Willcox or Douglas? Okay, so we're talking about a 12-month period preceding the call.
So the next question is anybody who has irrigation rights, like corners of pivots, do those irrigations, can they keep those irrigation rights even if it's on corners of pivots, if they plan on using on some other property that they have? Or do they lose those irrigation rights?
So if the acres of land, if the land has not been irrigated in the 5 years preceding the call, they're not eligible unless a substantial capital investment has been made to subjugate the land for irrigation.
Next up is Elaine Bailey, and our last comment card is Ray Eiley.
Thank you for going for a couple of minutes. All right, first a little bit afterwards, so I appreciate it. Thank you for everybody to be here, and thank you all for being here. I have 2 questions. The first question is, I understand that things will cease temporarily for the call for election. You have, not you, but people had a 6-month window or a 3-month window where it could have been shut down. Why was it waited for the last possible call for things to be shut down at 3 months, which will happen the end of this month, if I'm understanding?
Good question.
So the determination about when the call for the election had to be made was made by the county. And it was, my understanding is it was done, I mean, I can't speak for the county, but it was done with reference to, there's some statutory language in Title 45. You may have referenced, no, I don't, you may have referenced it, but there's some statutory language in there that talks about how early and how late the call can be made in relation to the election date. There's also election law that the county had to follow. So I'm not an election attorney. They made that determination about when the call should be made,
and I would like to know why. Do I need the mic? I've been an 8th grade teacher.
Yeah, no.
Okay.
So maybe I'm misunderstanding the question. So they are statutorily required to make a call for an election if the petition is verified, and they did verify the petition.
Yes.
With respect to the timing of when they made the call, there is statutory requirements in terms of the election has to be called, I might not have this exactly right, but it is essentially no earlier than 90 days, no later than 60 days before the date of the election.
Yes.
There were also some, again, I don't want to speak for the county, but I believe there were some election law related timelines that they had to follow in terms of, I don't know if it's issuing pamphlets or providing notice of the election.
Is there anyone at the table that can answer that question? Please.
I can answer it.
Thank you.
It is because we wanted to hold the election during the general election. Elections are extremely expensive, especially when we have so many early ballots we have to send out. Special elections are just out of the question if we've got an election coming up. The other reason is the Douglas INA, AMA, we were waiting. I mean, they were anticipating that they would finally get the ballots. Had we called for the election in time to hold it with the primary, for instance, we had enough in this valley, but not enough in Douglas. They weren't ready. So we kind of just waited only for logistical purposes, following all the laws, of course, but we tried to time it so that we would be able to hold this election during the general election.
Well, and the reason I even asked that is that where I am, and I'm in Elfrida, I don't think I even need this. Oh, okay. I'm in Elfrida, and in the last month and a half, there's so much natural land that has been scraped off that if it could have been done earlier, it would have stopped.
They didn't have the signatures in that.
They did, from everything I read and everything I understand, but I thank you for your point of view. Okay, my second question is, I did my homework. I definitely did my homework. My second question is the water coming to us? I mean, the water, we live here. This is our life. We all live here for a purpose. We love it here. And there are crops being grown that are being sent to Saudi Arabia. So my question is that well, not if, because I believe it's, oh, sorry. Okay, so when that happens, whichever way it goes, is that going to be stopped?
So I guess I would just say we've talked through sort of what the regulations and the restrictions are within an AMA, and those are what would apply.
Okay, so do I understand that there would be no regulations on so many crops going to another country with our water? If I understand it correctly.
So just in terms of where crops go, that's not something that's within the scope of what DWR administers.
And is there anyone that is in their scope?
No, I don't know the answer to that either.
That's not the answer. Thank you.
All right, our last comment card here is Ray Eiley. We do have one virtual comment card, but Nav Athwal, if you are still on the webinar, we'd be happy to allow you time to speak after this last in-person commenter. But I think he may have logged off here. So Ray Eiley.
Oh, thank you all for coming. I have two questions based on hypothetical things that may happen with this AMA. I own property in Pima County in the Tucson AMA with an exempt well. I'm familiar with the good, bad, and the ugly of that. We also own ranch land in Dragoon, Cochise County, which currently has no well, no grandfathered rights whatsoever. I purchased that land with the intent of using it for a variety of purposes. In the last year or so, the cost of drilling a well there, partially because of inflation and partially because of the run on drilling wells now, has gone from $30,000 to $54,000. Question I have is if the AMA goes through, who, if anyone, is going to compensate me for extra costs or the decreased market value of my property because of the loss of utility? And the second question I have is, let's say the AMA is approved. And let's say, we're in the middle of a big drought here, 1,200 year drought. Let's say it ends. Or let's say we get desalinated water. Let's say we get a pipeline from the Mississippi in here, which the state is working on. And all of a sudden, there's no need for, there's no water problem anymore. What process, if any, is there for ending the AMA and getting our property rights back?
So with respect to the ending of an AMA, I guess this is a little bit difficult to answer because the goal, depending on what the goal is and how effective sort of the plan is at meeting the goal, whether there's augmentation opportunities that might, satisfy the goal through an alternative mechanism. That's sort of something that we can't really predict, but it could potentially have an impact in terms of how the AMA was administered in the future. I don't know if that answers the question.
But there's no process to get rid of it.
Well, there's no, I'm just making sure I'm running, sort of thinking in my mind, if there's a process, there's no process in statute for doing it with an AMA.
Without compensation, anybody can compensate this?
So if that's so I can answer it to the extent if it's a legal question, or if it's a question about sort of taking or due process. So there is court precedent on this, that the legislature through the groundwater code created a mechanism that is legal, that does not constitute a taking in terms of creating management structures. I didn't answer that very straightforwardly, but I think I'm just getting a little tired. So that legally, that's sort of that answer.
All right, that is all the comment cards we have. We know we've run very long tonight, but we really do appreciate all of your participation tonight, all of you who showed up tonight. We know this was really dense. Again, I don't have my contact information up on the screen anymore, but I do have business cards up here. If you have any additional questions, please feel free to reach out. Again, we really appreciate all of your time and attention tonight. Thank you so much and have a good night, everyone.
Thank you, Natalie. You guys did a super job.
Thank you, Al.
I know, convenient, right?
How'd you turn it off?
Thank you.